I needn't point out that if you can't, there are alternative seats closer. But so I'm going to talk about the fair deal in contract law as a matter of justice. So the traditional view of this subject, or the view that you probably learned in contracts class, was that if we're talking about what A gives to B and what B gives to A, just the basic exchange of a contract, that the law says there has to be consideration, or otherwise the contract's not enforceable, but that the law doesn't care what that consideration is. So as long as there's something that each party is getting, the law is agnostic as to whether it's a reasonable thing to be getting or not. And this view has a lot of case law quotations that can be supported and treatises that support it. And if the law really took that view, then the law would be saying it doesn't care about whether the deal is fair or not. Right? It might care about justice in other terms. It might care about justice in terms of discrimination. It might care about justice in terms of procedural access to the court system to enforce your rights and so forth. But what I'm talking about is the deal itself, and that is a way of saying that the law doesn't care about the deal. So what I'm going to try to persuade you in the next few minutes is that that's actually not an accurate view of the law. And to do that, you need to, I would say, play along with me on the following propositions. That first of all, if we're talking about the law having a view of the justice of transactions, that it could be, in my view, it is that there's more than one standard of justice involved. That it's not just that there is a single view of justice in the cases or in the statutes, but that there's more than one view of justice involved. That, secondly, that they're not all consistent with each other. And thirdly, that we all believe in all of them to some extent. To put it another way, in my view, the law sees contracts and enforcement of contracts as actually quite a stew of justice, a realm in which the justice of things has to be discussed, in which the justice is not always obvious, but in which considerations of justice are there. Contract law is not, as it's sometimes taught, simply about freedom. It's not, as it is sometimes taught, simply about efficiency. It's also about justice, but it's about a realm of discussion of justice rather than any single one view of justice. So what I'm going to do basically is give you two pairs of justice claims, which seem to me in many ways contradictory to each other, but both of each pair of each pair are, in my view, in the law, just to give you an idea of what I think is going on. So the first pair is, on the one hand, the claim that exchanges should be equal, and on the other hand, the claim that exchanges represent honest bets on the future. So here's let's start with the exchanges should be equal. This is maybe the most straightforward view of what a fair deal would be, that each side gets equal out of the transaction. Taken very seriously, that's a very hard standard to use. It's a hard standard because, first of all, it's very hard to measure what things are worth in order to decide that they're equal. If you say with Thomas Hobbes that they're worth what the parties are willing to pay for them, then obviously you have no standard of justice at all. You just have a standard of consent. But if you say we have a standard of what they're worth, then the question is, well, what's your standard? And in a market economy such as ours, pretty much the only standard you've got is market values. And if you say, well, each party should get equal market values out of a transaction, in some ways that's perfectly consistent with common sense values. People who find out that the used car they bought, that the market value of that car was thousands of dollars less than what they paid, feel taken. And in that sense, they feel that they should have gotten a fair value, meaning an equal market value for the money they paid. But there are lots and lots and lots of things that are traded that have no market values. There may be a market value for the used car, but are there market values for the employee's promise not to compete for 2 years after he leaves the employment that he's signing up for? Well, there's no market in covenants not to compete. There's lots of things that are in contracts that would have no market value. And more broadly speaking, if you start using market values and insist that contracts have to adhere to market values, you kill the market, because the whole point of markets is that the prices fluctuate, that what was the market value today is not the market value tomorrow, and that's, Hayek would say, the most important thing that markets do is to reflect those changes. So to say market value in any hard sense is hard, and therefore saying equality in any strict sense is hard. That said, there is lots of law which takes what you might say a relaxed view of the equality point of view, which is to say rejects very unequal contracts. Just to give you an example, a recent example from Illinois, a woman along in years, living in a ritzy condo building in Chicago, made a deal with the person who was next door to her that she would will him her condo and all the furniture in it. So we're talking in the millions of dollars. If he would perpetuate her family name by making her family name the middle name of his children. Now, I don't know the exact circumstances under which this she was persuaded to make this deal, but the court says, well, I don't care how this came about. This is so unfair, we won't enforce it. Period. It's just the consideration of giving your kids a middle name is just not something that we can sell for millions of dollars. There's lots of cases that, more common cases in which courts refuse to carry through on real estate transactions, refuse to order specific enforcement of real estate transactions where they think that the property has been sold way, way below market value. So in that sense of a very unequal exchange, the law is there, and it's an active part of the law. Now, it's also what I refer to as the honest bet principle is also an active part of the law. So I'm sure that you all either do or know people who participate in one form or another of sports betting, and it's a common part of the morality of the society that if you lose, you pay up, and that's just it was a fair deal. And it's also a common part of the morality of the society that the deal has to really be fair. That is to say, it can't be rigged in one sense, one way or another. It can't be heads, I win, tails, you lose. Well, those principles turn up in the law too. Turns up in the law, for instance, in the sense that in any kind of speculative contract, the courts insist on both parties are bound or neither party is bound. That's just a simple way of saying that it's not heads, I win, tails, you lose. But if you think about it, this is productive of very unequal consequences. So let's take the most probably socially important example, insurance. All right. So suppose you have a policy for $1 million worth of life insurance, a term policy of, let's choose a number, say $1,000 a year for the next 5 years. That contract is going to come out one of two ways. Either you're going to pay $5,000 and get nothing, or you're going to pay somewhere between $1,000 and $5,000, depending on where you die, and your beneficiary is going to get $1 million. Whichever way it turns out, ex post, it's not going to be equal. The only way we can say it's fair is that actuarially it's fair. It's a fair bet. It's a fair gamble. Now, that result, $1,000 for $1 million, is not so different as the result in millions of dollars for changing middle names. But in one case, we think that the result, the very unfair result, should be rejected. And in the other case, we say, no, it should be accepted. And that's because we look very differently at the contract for handling a risk like death from the contract that doesn't seem to us to have that risk element in it. But that's because we have different standards of justice for the two situations. They come into conflict when what we have is just an ordinary commercial contract at a fixed price. And then we have an interpretive problem of whether the fixed price was meant to be insurance against the markets going haywire, in which case it's like an honest bet, or was simply meant to be the price at which the transaction was expected to go forward, in which case if someone has to give very much more than what that price would normally justify because markets has changed, he ought to be excused. And so the interpretation of which of those principles of justice is applicable is not always an obvious thing. Some judges say a fixed price always means a risk allocation, but that doesn't seem to me necessarily true. Why don't I go on and then ask if there are questions on that pair after I get through the whole talk. So the other pair I want to present you with is the justice of desert versus the justice of not taking advantage. So I suspect everybody who's an American believes in dessert one way or another. All right, he worked hard, so he deserved to get a good grade. She was a star in college, so she deserved to get into the Harvard Law School. He didn't do as much work as she did, so he deserves to get less money. I mean, we just talk that way all the time in our assessment of the society. Now, how does that apply to contracts? Well, because deeply embedded in the contract paradigm is the thought that if someone, through diligence and through intelligence and through being careful, makes a good deal where he or she comes out very much on the plus side of the transaction, if he does that without duress, without fraud, he deserves, to use the phrase that's used in the restatement, he deserves the benefit of his bargain. He deserves to have the good deal enforced. He deserves to win that transaction against the party that was not as good at being a contractor as he was. I mean, if we were to kind of try to put that as a matter of social theory, I think you'd have to go back to Herbert Spencer. You'd have to go back to the idea of survival of the fittest in order to justify that point of view. This is the fittest in the marketplace, if you want to put it that way. But if you want to just take it as a matter of common morality, being a, quote, good businessman, quote, is something which is positively valued in the society. How much is positively valued in this particular building, I don't know. But in the society as a whole, there's no question that being a good businessman is a statement of praise. We look to businessmen often to lead other activities in the society. And there are even people who think that is a ground for voting for president. Now, the positive valuation of that, of being a good business person, is another way of saying that we think that people who make good deals deserve to get the benefit of that deal. Now, we also think, in many respects, the opposite. Because, as we all know, what makes it possible to get a good deal or to be good at anything is partly a matter of what we might consider merit and partly a matter of what we would consider luck. And if you've been looking at the Olympics, the people who are doing terrifically in the Olympics, clearly, in one sense, it's a measure of merit, but it's also a measure of being born with physical attributes that can withstand the training. It's a measure of being supported by social systems that make it possible for you to train and train and train and train. It's, if we were psychological about it, we might say it's a result of having the kind of mentality that it lets you be so clearly focused on just one thing that you can do the kind of training you need in order to win the Olympics. So it's both luck and merit, and that's true of making a good deal too, of making a good contract. So just as we were just talking about, the good businessman or the person who makes the good deal deserves the good deal, we can argue the other side and say the person who didn't make such a good deal maybe is not culpable for not having those attributes. So just to show you how we are split on that, there are statutes what I think of as hurricane statutes. There are statutes, and I might say in exactly, I believe, 25 out of 50 states, there are statutes that say if there's a public emergency, you can't raise the price of things that are necessary for people to survive in that emergency. You can't suddenly take the bottled water you have and charge $20 for it. You can't suddenly take the electrical portable generator you have and charge double the list price and so forth, because that would be taking advantage of people who are in the same emergency situation that you are, and taking the happenstance that you have stuff that they need and profiting from it. So that half the states say that, and half the states say the opposite. Because you could also say you're the person who was smart enough and foresightful enough and so forth to have those things to sell to other people when they suddenly became more necessary. I think all four of the principles that I've spoken about, the not too unequal transaction, the honest bet, the desert for being good at economic events, and the not being taken advantage of, that we all believe in all four of those. We believe more in some and less in others. And so it seems to me that what we have is a realm of debate on the justice of contract law, as opposed to the idea that we don't care about the justice at all. We do care about the justice. We care about the justice a lot. We just are inconsistent or multifarious in our beliefs in that regard. Well, that's what I have to say. So, questions?
I will circulate
Oh,
microphone.
So I guess my question is that what do you see the consequences of the fact that there is this realm of justice that's considered in the law of contracts? Where do we see like the role of scholarship in deciding how that's going to affect future decisions throughout all of the jurisdictions that are considering this?
So one reason why I care about that is because it seems to me the scholarship of contracts has been too thin over the last 20 years, has talked too much about efficiency or freedom and not enough about justice. If you really want to find articles that talk a lot about this, you're talking about articles mostly before World War II, actually, where the economic results of contract were much more clear. One thing that hangs on this from a kind of political point of view is, let me put it this way, the difference between the words distribution and redistribution. All right? So what the common law of contracts and property produce is seen as an accepted distribution in the society. All right? And then if we talk about changing that, say, by the tax system or by grants of one sort or another, that's seen as redistribution. Right? Redistribution requires a political will which is often not there. If things are different at the level of distribution, that makes a real difference, right? So I think it's easier, it's more accepted if you want to talk about current political debates, the movement to raise the minimum wage, which is operating through the contract system, through the market system, is, I think, politically easier than it is to achieve the same result by having a new welfare reform or something like that.
When you were talking about the two principles and then two pairs of principles, it looked to me that you were talking a lot about equality, in the sense that when you talk about this justice deserved or not deserved, if it's merit or not merit, can we relate that to the equality between the parties, or even to the not equality, like they are unequal, like in the bargaining power, or even during the performance of the contract? And also how that relates to the idea of change of circumstances that you also said, the idea that something can happen and that can create the change of the price and makes it become unfair, even if it wasn't in the beginning, because once we can talk like in the beginning of the contract, when the contract is made, maybe in that moment it wasn't unfair, but then during to the change of circumstance, then change. And how can we relate to those principles that you presented?
So let me take the second one first, all right? It seems to me what you're just talking about is one of the key questions about how you interpret fixed price contracts, all right? If you see them as apportioning all future risks known and unknown, then the fact that factor prices change doesn't means that the deal should still go at that price. If you see it as, well, this is our agreement as to what it's going to cost, because I have to some idea of roughly of what it's going to cost. I have some idea of how to enter it in my capital plan for next year and so forth. But I'm not really trying to nail you to the wall to that price. Then you might much more easily adjust as things go along. I think probably business people are more fluid on the actual meaning of a fixed price than at least some of the cases which say no, if there's a fixed price, that's it. Now on the equality question, you're talking about the equality of the bargaining position. Is that what you're saying? So here's where the big fighting issue over that is in contract doctrine at the moment, all right? The fighting issue is, does duress exist only when, or does the other party have to take into account your circumstances only if the other party caused them, in whole or in part? So the standard doctrine of duress says yes. In other words, the standard doctrine says you have to be in a hard position with no alternatives, and you have to be there wholly or partly because the other party put you there, no longer necessarily by pointing a gun in your belly, but by various machinations of one sort or another. As against this is the position taken by the cases on unconscionability, which take the position that a contract can be unconscionable in part because of things which are true about you but which the other party didn't cause, such as lack of education or something like that. The Fair Labor Standards Act, which is the national minimum wage law, you might see as taking the second point of view, that people who are unable to get a very good wage bargain, which after all is a contract, unable to get a very good wage bargain because they don't have much in the way of skills, so they don't have much in the way to offer as market power, but they still have to live like the rest of us, and therefore need an income of a certain level that they are, you might say that's a statutory determination that they are under duress, although not as a result of anything that the person on the other side of the transaction did. Right. The statute I mentioned, the hurricane statute, would also be in the same thing. The person who's trying to get more money from you didn't cause the hurricane, but is not entitled to ignore it. So I would say that's the question of whether taking advantage of other people includes taking advantage of them when you're not the cause of their disadvantage is probably the fighting point right now.
So I actually have a couple of questions. The first is on this last point, in mentioning the Fair Labor Standards Act. I sort of want to say, when I was learning this stuff, the Fair Labor Standards Act would be understood as regulation external to contract law. And you are saying, well, when you're learning contract law, things that TouchNet wants to characterize as regulation are part of the domain of contract law. So could you say something about that?
So, it's very hard to give an account of contract law at all on the ground these days without bringing some statutes in, since so much of the traditional corpus of things that were discussed in common law are now statutory. On the other hand, if you bring all of the statutes in, then it seems like you're in some other domain, maybe the leg-reg domain. So I think one possible stopping point, which may be whether it's a theoretical stopping point or just a practically available stopping point, would be statutes that are enforced through individual lawsuits versus statutes which require positive administrative action to enforce. On that standard, the typical way, the Fair Labor Standards Act can be enforced either way, but the typical way that it's enforced is by someone suing for the wages that they didn't get. It's not waivable by contract. It's an ordinary lawsuit. There's attorney's fees for that lawsuit, so in fact the private action is encouraged by the statute. So I think I would include that within the domain. It's similar enough to contract law, because if you don't include those kinds of things, then a lot of the things which the judges are doing to update contract law or to update our view of transactions, you'll never notice them because they'll be off in consumer protection law or something where you wouldn't understand that they were going on. Do you disagree with that?
No, it's just, it's an interesting observation about the curricular divisions that we've created. Really, that's all. Again, 40 years ago, when I was learning contracts, taking more than 40 years as a first-year student, there was, everybody knew, and instructors said, there's this body of statutory law, but what we're learning are the principles of contract law. Now, it might be interesting, actually. I don't know. I haven't taught contracts ever. whether you can see influences on what I would classically call contract law of things like minimum wage statutes.
Well, I guess we could start by, and I don't know the answer to this, start by looking at the 5 most used case books and just see what turned up.
Right. Okay, so I another question,
Sure.
which is this is also about sort of, in part, how I learned the doctrine, and so, the 20 years of scholarship issue that you've raised at the beginning is relevant here. I would have thought that one response to your overall argument is, yes, of course, all 4 of these ideas of justice are rattling around in the cases. But the second one in each pair, the non-market idea of justice, is deviant, as some people would characterize it, or subordinated, or in the more polite versions, the better reasoned cases adopt the market-oriented standard. The market, it is a notion of justice, but the notion of justice that's embedded in contract law is that particular one. Now, I think you want to say there's no preference. There's just, as I think you put it, a dialogue within contract law among these 4 ideas. So what's your reaction to the, sure, there are these things, but the ones that aren't market-oriented are not very well reasoned?
So I think one that has gone down in the last 100 years, if I want to put it that way, is the one I tagged Herbert Spencer with, the survival of the fittest idea. The idea that you deserve the advantage of a good deal you made because you're good at making good deals is something that I think has less support than maybe it used to have. It's been under that particular thing as a measure of damages, or as a remedy, has been under attack at least since Fuller, because Fuller's view of why you get the expectancy was not based on that idea. So that's been under attack for a while, and I think people in the society have a little bit more sympathy for the don't take advantage of people than they used to. On the first pair, I'm not so sure that it might not be as you suggest.
What would be for you the idea of good faith and related to justice? Like, could we argue good faith for the parties in this case that you said, okay, I acted in good faith, I deserve the prize?
In American contract law, there is no doctrine of good faith in bargaining. This is not true of European contract law, but it's true of American contract law. And so often these questions of what advantage you can take of the other party are argued out in terms of, does this constitute duress or does this constitute fraud? Do you have, for example, the question of, do you have an affirmative obligation to tell somebody the defects in your house when you're selling to them, would be argued as a question of fraud rather than as a question of good faith in this country.
Okay. Is there anything else? I didn't see any other hands. Well, thank you. We
All right.
should get out. So the next class can come in. Thank you very much.
Okay.